Hi everyone, my name is Rachael Nilsson and I am the Children's Court Attorney for the 1st Judicial District Attorney's Office. The 1st Judicial District Attorney's Office services 3 different counties, so Santa Fe County, Rio Arriba County, and Los Alamos. I just want to take today to go over the process of a juvenile case, going through my office and basically what we're looking for when it comes to screening, diverting, or prosecuting cases. So with today's presentation, we're going to talk about a few things, including the fundamental purpose of children's court, the journey of a case both before and after filing, the different timelines and outcomes we look for in these cases, the work we're doing with diversion, and when juveniles are taken into custody, what that looks like for our office, especially our timelines, the role of parents and guardians, and finally, the times and incidents when we do file for adult sanctions. Those are few and far between, but it does happen. So first, we're going to talk about the fundamental purpose. This fundamental purpose was set forth by the New Mexico legislature. This is what informs all of our decisions and goals for the child throughout the entire process. This applies to everyone involved in the process, the courts, my office, the defense attorneys, and the juvenile process as well, and that goal is rehabilitation. Rebellion is a normal part of growing up, especially for teenagers. They're trying to figure out who they are, where do they fit in, and basically how to become a person. So our goal is to find where normal teenager rebellion begins and where it turns into self-destructive behaviors that lead to law enforcement attention. So we try to use these psychological assessments you heard JPO talk about. These are performed by professionals, and they give us pretty much a holistic view of the child. What are the past traumas? Where are the issues? How are they doing in school? What does their family structure look like? And if they have any issues, how can we address that and make sure it doesn't follow them into adulthood? A lot of issues would be considered a familial issue best left up to the parents or guardians, but like I said, once it comes to the attention of the law enforcement agency or JPO, that's when we do step in. Like I said before, this is a very holistic approach. In adult court, we like to work in snapshots. So we work with what incident happened. We look at the incident, the evidence, and we deal solely with that incident. Well, with juvenile justice, we are looking at the entire situation. What resources do they need? What are the issues? What does their familial structure look like? And that's going to inform our resolutions going forward. And using all of this and looking at this, we do like to utilize community engagement. Like I said, a lot of times it's a resource issue. So we're going to use our community and all the resources available to us to wrap the child around with services in order to guide them in a better and safer direction. One of the things I like to use a lot, the JPO office can tell you, I love giving children community service. I think it's important for them to do something outside of themselves, enter into the community, and get out of their bubble. It doesn't always mean picking up trash on the side of the road. They a lot of times choose where they want to serve. So they can go to the animal shelter, or they can go to Kitchen Angels to help make food packets, or even build homes for Habitat for Humanity. I think this is important to make the kids see the world outside of themselves and learn empathy and accountability for their actions. So in order to achieve all this, we're going to move on to our third prong, which is parental supervision. The parents and the guardians are the single most important player in this process to make sure their child succeeds. Their involvement in the child's treatment and new opportunities going forward help their child succeed and not reoffend. We don't want to do the job of parents. We want to help the parents, the child, the family succeed. And so our job is to help give them resources and point them in the right direction. And finally, treatment and support. You heard the JPO officers talk about this earlier, but we like to use our community to make sure that their issues are addressed. Either that could be substance abuse issues, problems with school, destructive behaviors, or anger management issues. We help them basically however we can. That could be getting them a job, helping them out with school, or finding other treatment options that best addresses them. So this is the process of a case that is filed. It takes a while for juvenile cases to get filed. And this is because of the time limits that we are working underneath. So if a child is held in detention, we have 30 days to reach a resolution. If they're not held in detention, then we have 120 days. This means that we lean heavily on our law enforcement agency partners to complete their investigation before handing it over to JPO, before handing it over to us. Because frankly, once we file, we're off to the races. We don't have time to deep dive and investigate cases. And furthermore, we have to meet the same legal standards for a juvenile case as we would an adult case. So we still have to meet the legal standard of sufficiency of probable cause and potentially beyond a reasonable doubt when going into this. So here you see that the incident occurs and the law enforcement investigates. They can consult with us on charges, either by calling me during working hours, or if it's on the weekend, or not, calling the DA that's on call. After that, it is given to the JPPO for review, and JPPO is going to decide, using that RAE metric, whether or not to hold the child in detention. From there, they conduct their preliminary inquiry, and then they're going to refer the charges to me. I'm going to get that PID that includes the chronological history of past offenses, and I'm going to look at that and the police reports and all of the evidence and decide if we should file, if we should not file, and also whether the charges are correct or need to be amended in any way. So I'm going to ask myself several questions when I do get this, and I have 60 days to look at the case before filing. And I'm going to ask myself multiple questions, including, can we meet the legal standard for this charge? Is there enough legal sufficiency for me to bring this forward and prosecute the case? Is the evidence in? Are we missing evidence? Do we need to find the evidence before I make a final decision? And then we're also going to ask, can this be handled by diversion? We're going to go over diversion in a little bit, but sometimes it's a resource issue or it doesn't rise to the level of needing prosecution. I'm going to ask myself, what is the case history? Is this the first time I'm seeing this kid, or is it the fifth? And finally, I'm going to ask myself, should we file this case? Is there something else that can be done before we take them through the juvenile justice process? And then we're going to, if we decide to file, we are going to have a court date set to appear in front of Judge T. Glenn Ellington. He handles all of the juvenile cases for all 3 counties. He's been doing it for quite a while. So once a case is filed, we're going to have a first appearance hearing, and there's going to be several parties at that hearing. Most of the time, they are virtual. It's going to be the child and their parents or guardians. I'm going to be there. The defense attorney, most of the time, Peter McLeod, steps in for the law office of the public defender. The JPO and the judge will be there. The charges will be read to make sure the child understands what they're being charged with. The potential penalties are going to be read. And then most likely they'll enter in a denial, which is like pleading not guilty, and it reserves their right. From there, we are going to get an update from JPO. They kind of give a background of information to the court, to me, and we set conditions of release, which can include everything from GPS house arrest, random drug tests, attending school or another educational program with no unexcused absences or tardies, abiding by a curfew as set by the parents, no contact with the alleged victims or co-defendants, and completing an assessment. Almost all of these kids will complete some sort of assessment, and we're gonna use that assessment to decide where the problem areas are, where the issues are moving forward. And then if they haven't by then, they will be ordered to either apply to the law office of the public defender to seek counsel or hire their own attorney. At that point, they will get the phone number for the law office of the public defender to help push them on their way. Like I said, we use the assessments. These are often done through team builders. It takes a few weeks, but it also informs our decisions moving forward, and it also plays a direct role in the negotiations. Before I start negotiations, I a lot of times like to email or contact their JPO officer, ask how they have a feel for the kid, what's going to work, what's going to not work. They have had the direct interactions with the kid and with their family, and so they are better equipped to give me an idea of what's going on. They also tell me how the kid's been doing on conditions of release. Have they been struggling? Have they been not? This kind of gives me a whole holistic view of what's going to work best in the plea negotiations. We try to come up with a plea deal that is going to make sure to rehabilitate the child and make sure that we don't see them again, at least come across our desk. I really enjoy children's court. It's not as acrimonious as adult court. The fact that most defense attorneys are also working in the best interest of the child to rehabilitate the child. So most of the time we can come up with some sort of plea hearing or plea agreement, whether that be probation, a consent decree, or even a commitment. We have sent kids to residential treatment centers to get help with substance abuse. But we try to work together to find out what's best for the child. So most cases end up in an adjudicatory hearing where an agreement is proposed and we reach that final disposition. From there, if they successfully complete all of their program, their treatment, whatever is ordered, we can close out the case. However, if they're struggling or they violate or they pick up new charges, we can revoke their probation and extend the disposition. This can be extended all the way up until they're 21. One thing that is different, that there's no distinction between misdemeanor crimes and felony crimes for juvenile cases. So all cases have the potential, have the same maximum penalty and the same, which is up to 2 years of YDDC that can be extended up to 21, until the age of 21. So like I mentioned before, we're working under extremely tight deadlines. So once a child is in detention, we have to see them within 24 hours and either have a detention hearing, which we ask the judge to keep them in detention, or we can set conditions of release. As has been said before, we have very few beds available since we don't have our own detention center here in Santa Fe County. We have 7 beds for Santa Fe County. We contract out of San Juan and 3 for Rio Arriba County. And then, as stated before, one of the big questions I always get is whether or not this is going to stay on their record. If they're completely done with their disposition when they turn 18, so they've been sentenced to a year probation, they complete that year, the case is closed out, they've been successful, their adjudication, which is what we call convictions, fall off their record or are sealed. There can be some issues if they do want to go into the armed forces and they have to get a security clearance, but we can usually try to work around that. So this is something that I'm extremely proud of. Jennifer Paget Macias and Linda Freeman have been working extremely hard to get this up and going throughout the Judicial District and to widen its scope to try to reach more kids. So juvenile diversion seeks to intervene kids who lack resources or direction. I always like to say that a bored kid is going to start looking for trouble in a place that you don't like. So if we can help these kids who don't have access to resources or mentors or even a community they can lean on, we can step in, help those kids that are sight unseen, and push them towards something that interests them. These are a few of our partners that we've been working with. Moving Arts is located in Espanola. They are doing a great job finding these kids a passion. Most of the time in the art world can also include dancing. We have a girl doing gymnastics who is thriving. Pivot is our Prosecutor-led grant-funded diversion program that seeks to divert kids away from violence. It's our violence intervention program. And Uplift Youth is located here in Santa Fe County. It is our Santa Fe division of the Pivot program. We're currently in the works with the county and city of Santa Fe to get that up to full speed. A lot of times these kids are overlooked. They don't have access to as many resources as we would like. And so we're trying to find them and keep them out of the criminal justice system by pushing them towards resources and a passion that can help them become happy, healthy adults. So we have talked about how we have very little beds in for our judicial district, but here are just a few things that we are looking at, which included that they have committed a delinquent act, so not a status crime. Status crimes include incorrigible or skipping school. This has to be a delinquent act. They need to be older than 12 years, a substantial risk, a danger to themselves, or leave the jurisdiction, or a danger to others. A lot of times they were already on conditions of release and have violated in some way. This is a placeholder to hold them until we figure out where the best place is for them to go. We don't like to hold them and keep them there until a resolution, but if they are an articulable risk to themselves or the community, we will hold them until we reach a resolution. However, most of the time, we hold them in detention. We figure out where is a safe place for them to go. Is their parents equipped to handle them right now? These are all questions that we have to ask ourselves. So the role of parents and guardians, parents can be joined to the proceeding. We call this parents party to the petition. In this, the judge can use their contempt powers to make sure that the parents are fully engaged and doing whatever needs to be done, whether that's taking them to the courthouse for their hearings, or taking them to therapy appointments, or taking them over to the JPO office to make sure they check in properly. They cannot be ordered to pay restitution or fines. However, if their child is found to be delinquent through an adjudication, they can submit to counseling and also be ordered to take place in their child's treatment, whether that be in an outpatient treatment or within a facility. So this is a topic that is pretty heavy. So there are two instances in when two different forms of times when we can ask for adult sanctions, so that is adult penalties for juveniles. The first one is going to be a youthful offender. That is kids between the age of 14 and 18 who do any one of these enumerated crimes. So if it's not in this list, can't do it. This includes everything from second-degree murder to abuse of a child to robbery, aggravated burglary, or various sex crimes. Here, we file a notice of intent to seek adult. Marbles in my mouth. Notice to seek adult sanctions, and then we go on from there. We still have to meet adult proof. So we still have to meet beyond a reasonable doubt, probable cause when moving forward. So we're going to have either a preliminary hearing or a grand jury indictment before moving forward. And then if they are adjudicated as a youthful offender, we're going to enter into the amenability phase. And that's a separate hearing where we are going to talk about whether or not the child is amenable to treatment. If they're amenable to treatment, if the judge finds they're amenable to treatment, they will be adjudicated as a child. So they're going to receive juvenile sanctions. If they're found non-amenable to treatment, they will be sentenced as an adult. Our second instance when we do this is serious youthful offender. This is for kids who are 15 to 18 years of age, and it only applies to one charge, first-degree murder. Again, we're going to go through the preliminary hearings or grand jury indictment, but there is no amenability phase if they're adjudicated as guilty. They are going to be sentenced as an adult. This is something that is only used sparingly in a very few amount of cases. This is a time my office especially asks, should we upfile? So I don't think I took up all of my time, but if anyone has any questions, please let me know. My contact information is up here on this slide. Please feel free to email me. If I don't have an answer to your question, I can probably find it or find someone who does. Thank you. It's been an honor to present at the Juvenile Justice Summit the work that the 1st Judicial District Attorney's Office is currently doing in children's court here in Santa Fe, Rio, Reba, and Los Alamos counties.